And Mr. Perry, you are currently in the employ of the Department of Health and Human Services, is that correct?
Yes.
In the capacity as an adult protective services worker?
Yes.
And it looks like you caused to be filed yesterday a petition requesting appointment of a guardian for Linda Watkins, is that correct?
Yes.
And can you outline for me the reasons that you filed that petition?
So Adult Protective Services on Monday, March 23rd, received a referral. There were concerns of self-neglect and neglect. For Linda Watkins, it reported that Linda, who has had strokes and is a right above the knee amputee, resides with her husband, Glenn, and that Linda had fallen out of her chair, and it was unknown if she was receiving care, and also that Glenn was not able to get her up. So I contacted Glenn that day on the 23rd and previewed the concern in the report. He was at work. He said it was true that on 4 days prior, so that would take us to March 19th, Thursday, Linda fell out of her chair. He discovered her shortly before or after 5 o'clock on the 19th. I asked if she was still on the floor, and he reported she was. Then I questioned why he had not sought medical attention in 4 days. And he said that he had reached out to his son-in-law, and he wasn't able to assist. And Glenn himself wasn't able to get Linda up. He also contacted EMS to inquire about the cost it would take to transport Linda to the hospital. And he said it was $1,800. So it was a financial barrier for him. I advised, based on what I was hearing, that he leave work and meet me at home, and we call 911. So I arrived at the home shortly thereafter, and I observed a woman coming down the ramp, and she identified herself as Jessica Watkins, daughter and to Glenn and Linda. She reported just being in the home. I advised I was calling 911, and she was thankful for that. Glenn arrived shortly thereafter, and I followed him into the home, and he carried on conversation with dispatch to provide information. At that time, Glenn gave me permission to enter the home, and I was able to observe Linda Watkins on the floor. She had a blanket covering her up to her face. She wasn't able to communicate, and it didn't appear was aware of my presence. She was whimpering and appeared in pain. Shortly thereafter, ambulance arrived and transported Linda to Otsego Memorial Hospital. I further had a discussion with Glenn about the circumstances. He verified she was, throughout that duration of 4 days, defecating and urinating on herself, that he was doing the best he could to clean her up. He wasn't aware what medications she was supposed to be taking or if she was taking them. And I didn't get the impression he administers or is responsible for providing her medication. So from there, I learned she was discharged to Munson Medical Center in Traverse City on the 24th, and then coordinated with the hospital there and staff of my open case and concerns. And they recommended, upon their evaluation, she would require a guardian because she didn't have capacity. And they noted some concerns of Glenn, his behavior at the hospital, as well as the circumstances would not be the appropriate nominated guardian. I then had discussions with Mike Watkins' son, Glenn Watkins II, and Jessica Watkins, and advised I would be petitioning and nominating son Glenn Watkins II.
And I have in the court's receipt a report of physician dated March 26th of this year, signed by Dr. Jonathan Bulak. Have you seen that, Mr. Perry?
I have.
And you're familiar with its contents?
I am.
aside from what you've already reported to me in your testimony, is the report of physician also part of the basis upon which you bring your petition?
Correct. Yes.
And this was presented to me as an emergency petition. And you can correct me if I'm wrong, sir, but I gather the emergency is the fact that Ms. Watkins had to be taken immediately to a medical facility and is still in a medical facility needing treatment. Is that fair?
Correct. She had pressure ulcers as a result of laying on her right side for an extended period of time, septic, and MRI showed possibly a recent stroke.
Okay. Mr. Brown, do you have any examination of Mr. Perry?
I do not, Your Honor.
All right. Mike and Glenn Watkins, second, do either of you have any questions of Mr. Perry that I have failed to ask?
No, Your Honor.
Not at this time, Your Honor.
Okay. Mr. Glenn Watkins, you guys can unmute. Let's see if we can hear you this time. Can you say something so I can hear it? See if I hear you. We still can't hear you. To my clerk there in Otsego, is there a number that they can call in? Can they, a Zoom number or a courtroom number they can call into, or we get to just do audio?
If they can call 989-731-0243.
Ma'am, I don't know your name, but you with Mr. Watkins, did you get that? Okay, well, wait a second for you to call. While we're waiting for them to call, Jessica, if you can unmute, did you have any, well, 1 second.
Hello.
Good morning. My name is Kate. I'm calling on behalf of Glenn. Sorry, I think that's my speaker.
Right. It would be easiest for us if you disconnect from the Zoom while you're on the phone.
Oh, disconnect from your Zoom?
I can.
Okay. Yes, sir. We're here, Your Honor. Can you hear us?
I can. Can you go ahead and identify both of who we have on the line?
Yes, sir. My name is Catherine Darris. I am a friend to Glenn Watkins. I've been helping him try to get medical help for his wife. And this is Tasha Dunham. She is also a longtime friend. And then Mr. Glenn Watkins is with us as well.
Okay. So, Mr. Glenn Watkins, do you have any questions of Mr. Perry that I failed to ask?
No, sir.
Okay.
He said no, sir.
Okay, thank you. And as it turns out, I can hear him okay, so I should be all right with him. Jessica, do you have any questions of Mr. Perry I failed to ask? You're muted still.
No, Your Honor.
All right, thank you. Mr. Glenn Watkins, the second, if you can unmute, ask you to raise your right hand. You swear to tell the truth? No, I'm talking to Glenn Watkins, the son. Do you swear to tell the truth? You swear to tell the truth, the whole truth, and nothing but the true self you got?
Yes, I do.
And also, if you could state your full name for the record again and spell your last name.
My name is Glenn Orson Watkins, Watkins, Roman numeral 2.
All right, thank you. And Mr. Watkins, the petition that was filed by Mr. Perry from Adult Protective Services requesting a guardian has nominated you to be guardian. Are you aware of that?
Yes, sir, I am.
And are you able and willing to serve in that capacity?
Yes, Your Honor, I am.
Do you have any criminal record?
No, sir, I do not.
Have you ever been, I'm sorry, I cut
It
you
was
off.
actually a misdemeanor case against me for it said that I ran over a stop sign in 2 mailboxes back in last July that I'm currently dealing with in Wexford County.
Okay, so what is the charge? Malicious destruction of property?
Yeah, yes, sir.
Okay, that's pending. It's not resolved.
That is correct.
Okay, other than that, anything else?
No, sir. Not even a speeding.
Okay. All right, have you ever been investigated by Child Protective Services for claims of abuse or neglect towards a child?
No, sir.
Have you ever been investigated by Adult Protective Services for claims of abuse or neglect towards an adult?
No, sir.
All right. All right, Mr. Brown, did you wish to have any examination of Mr. Watkins II?
No, Your Honor, thank you.
All right. Mr. Mike Watkins, did you have any questions of Glenn Watkins II?
Not at this time, Your Honor.
All right. Jessica, did you have any questions of Glenn Watkins II?
No, Your Honor.
All right. Do we still have Glenn Watkins? I'm gonna call him Senior. Do we still have him on the line?
Yes, sir, we're here.
Okay. Does Glenn Watkins Senior have any questions of Glenn Watkins II?
No.
Okay. Now, while I have you still Glenn Watkins Senior, do you have any opposition to the request that a guardian be appointed for your wife?
No.
Jessica, do you have any, before I go to Jessica, Mr. Glenn Watkins Senior, I also needed to ask, are you in agreement with your son Glenn II being appointed as guardian then?
Yes.
Jessica, do you have any opposition to Glenn II being appointed as a guardian?
No, sir.
Mike, do you?
No, Your Honor.
All right, and for all of you, I don't mean to be so informal, but I just think by using your first name, but I just think it's easier to identify when we have so many family members, so I don't mean any disrespect to you. Mr. Brown, did you wish to call any witnesses?
No, Your Honor.
Mr. Glenn Watkins II, did you wish to call any witnesses?
No, Your Honor.
Mike Watkins, did you wish to call any witnesses?
No, Your Honor.
Jessica, did you wish to call any witnesses?
No, Your Honor.
And Mr. Glenn Watkins Senior, did you wish to call any witnesses?
No. No, sir.
All right. Mr. Brown, your position as guardian ad litem.
Your Honor, this report came in very late yesterday afternoon. I did review it. Late that evening, I had a conversation with Glenn Watkins II. I was unable to meet with Ms. Watkins, but based upon the report, based upon the testimony heard here today, I do believe that she is in definite need of a guardian. And I have no objection to Glenn Watkins II.
All right. And I assume on this, Mr. Brown, do you agree there's no need for a posting of any bond?
I would agree with that.
All right. All right. Court credits the testimony of Mr. Perry. Also credit the testimony of Mr. Glenn Watkins II. Court further takes into account the position of the guardian ad litem and credits the report of physician that the court received. And also take into account the position of the family members that are present and have identified their agreement with the relief that's being sought. On the record before me, I will note that we set this for an emergency hearing. The court finds that that was proper to set it for an emergency hearing and to shortened notice requirements because of the circumstances that Mr. Perry found and testified to. I'm giving an abbreviated version, but Ms. Watkins having apparently suffered from a stroke, having pressure ulcers, and having been in a condition of being septic, and having been in a condition of laying on the floor for quite a number of days without the benefit of treatment and being frankly picked back up and appropriately cared for. The further testimony of Mr. Perry outlines those circumstances relative to Ms. Watkins in terms of how and when she ended up on the floor and the actions and lack of actions that followed, all of which support that she certainly needed to go to the medical facility. She was taken there, obviously, and then, you know, some additional information was forthcoming regarding her current health condition and some of the concerns that were articulated by Mr. Perry as to some of the things resulting from her being on the floor for that period of time that was identified. So the court credits Mr. Perry's testimony. Again, it finds an appropriate basis for emergency. And also, we credited Glenn Watkins II. I do also find that he's qualified and able and willing to serve as a guardian, and I will appoint him in that capacity. What I'm going to say is from the standpoint of family members, they're all present. This was a very quick notice hearing. I'll appoint Mr. Glenn Watkins as a temporary guardian. I'll allow a period of 30 days in which to, for any family member, if they want to have any further hearing on this, because it was so short in terms of the notice of it, somebody may leave here and say, well, I think the judge ought to know about X, Y, or Z, or some other piece of information. That's fine. I'll leave a 30-day window open for you to contact the clerk and request a hearing, and we'll do that. But after that 30 days, if I don't hear from anybody, then I'm going to change it to a permanent guardian, and change the temporary status to permanent. Mr. Glenn, but to be clear, even as a temporary guardian, Mr. Glenn Watkins has authority to make medical decisions related to Linda Watkins that are in her best interest. The one qualifier I give Mr. Glenn Watkins is I don't allow, at least at the outset, we can talk about this a little further, but I don't allow the cessation of life-sustaining treatment without a court hearing. So if something's happening where Linda has some event that occurs medically that there's a question about that, then we need to have an emergency hearing, and I need to hear from the physician about what's happening with her. There are a couple of exceptions to that, and we'll cover that right now, and medical staff may be able to assist me as well, but I'll speak with you first, Mr. Glenn Watkins II. Are you aware of whether there's any DNR status that's been executed or code status that was on file for your mother?
I do not, sir. I don't know anything about that.
Okay. Ms. Delzell or the other folks at Munson, do you have anything in your system that indicates a code designation or DNR designation?
Mrs. Watkins is currently a full code.
She's a full code?
Yes, sir.
Okay. But you don't have anything in your system that indicates, this is a little different question, but any kind of a healthcare power of attorney, do you?
I have confirmed with Mr. Glenn Watkins Sr. that she had not previously done a healthcare power of attorney.
Okay. And thank you. And then as to Mr. Glenn Watkins II, to your knowledge, there's no healthcare power of attorney, is there?
Not that I'm aware of, sir.
All right, Mike Watkins, are you aware of any healthcare power of attorney?
I am not, Your Honor.
Okay, Jessica, are you?
No, Your Honor.
And Mr. Glenn Watkins Senior, are you aware of any healthcare power of attorney?
He's asking you if you're aware of any healthcare power of attorney.
No, there's none that I know of.
Okay. All right, thank you. Then, so Glenn Watkins II, I went through that just to confirm. Sometimes people before unfortunate circumstances like we have here have already put something in place that designates some decisions they've made regarding treatment. We don't have that in this situation. So again, what I'm vesting you with is you will have full authority to make medical decisions regarding Ms. Watkins, with the only exception being that you don't have authority to end life-sustaining treatment. And if something's going on where you want to change her code status from full code to no code, meaning where the hospital staff would not, healthcare officials or healthcare professionals would not take steps to resuscitate her, as an example, she had a catastrophic event that that would require coming to court and having the court review the circumstances to determine whether to give you that authority. Ms. Delzell, you wanted to add something?
May I kindly request reconsideration of end-of-life decision-making, as her current circumstances would warrant transition to hospice?
Well, is there a doctor available that wants to talk about her current situation?
Unfortunately, Dr. Bolak is in another meeting. However, I, as a nurse practitioner, would be able to talk in that regard if you would allow.
Well, I'll swear you in. Let's, if you'd raise your right hand. You swear to tell the truth, the whole truth, and nothing but the true self you got?
I do.
And state your full name for the record again and spell your last name.
Sure. Breann, Breann, Delzell, Dalzell.
All right, and you are in the employment of Munson Healthcare, is that right?
That's correct.
As a family nurse practitioner?
Correct.
And apparently you have had some involvement with Ms. Watkins from a patient care standpoint.
I have.
Can you detail that for me?
Sure. I am consulted. I am not her primary provider, however, consulted in the regard of her capacity to make informed decisions and cognitive impairment. Additionally, her frailty status as a geriatric woman.
Who is her primary?
Her primary is through the hospital medicine team at Munson Medical Center. Today, her primary is Larissa Fisher. She's a physician's assistant.
And so what is Ms. Watkins' circumstances that make you request the court consider a change relative to code status authority?
Sure. So Ms. Watkins presented with significant sepsis, an acute kidney injury, elevated troponin levels, which are her cardiac enzymes. Additionally, another acute or subacute stroke. Due to her history of significant strokes, Mrs. Watkins has advanced dementia due to vascular disease. This is leaving her in a position where she has become dependent on others for all care, including nutritional intake. She needs to have someone help her with her personal hygiene. She is struggling to maintain a seated upright position independently without someone holding her up and being supported. Based on the fact that she has reduced oral intake, she is bound to the bed at this point. Her palliative performance score is estimated to be around 30%, which, based on the palliative performance score and her advanced dementia, could present with a life-limiting circumstance of approximately 1 to 2 months. With that consideration, I believe that it would be appropriate to change her code status to a do not resuscitate, knowing that her likelihood of showing a meaningful improvement should she undergo resuscitative measures would be very poor, and could likely lead to further decline in quality of life, pain, and suffering.
So I think you just said this, I'm gonna frame it slightly differently. If she continued to be full code and had an event that required resuscitative efforts, is it your opinion that those efforts would cause her more pain and suffering than they would be worth, in the sense that the benefit that she got would not be much in terms of improving her health situation or quality of living, but the amount of suffering that she would engage in through the process would be significant. Is that fair?
That is fair.
All right. Is there anything else you wanted to tell me about her circumstances, or have you think we've covered it?
I think we've covered it. Thank you.
Okay, I think you said this, but before I swore you in, you were saying she is essentially in or headed to hospice. Is that right?
I think that she is a candidate for hospice, so allowing the authority of her son to have a shared decision-making with her care team, I think would be appropriate.
And did I understand, you use some, what I'll call healthcare lingo, but did I understand from your testimony that you believe her life expectancy to be about 1 to 2 months?
Based on the palliative performance scale, which is a nationally recognized tool that we use to gauge life expectancy. Yes, sir.
Okay. Mr. Glenn Watkins, Senior, do you have any questions of Ms. Dalzell?
I'll pass it along, Your Honor. He's not, judge is asking if you have any questions regarding what you've overheard.
No.
Okay. Jessica, do you have any questions of Ms. Dalzell?
No, Your Honor.
Mr. Mike Watkins, do you have any questions of Ms. Dalzell?
I agree with Ms. Delta. I do not have any other questions, Your Honor.
All right. Mr. Glenn Watkins, II, do you have any questions of Ms. Dalzell?
No, sir, I do not. I agree with her as well.
All right. Jessica, do you agree with the request to allow your brother to have authority to change the code status for Ms. Watkins?
Yes, Your Honor.
All right. Glenn Watkins, Senior, do you agree with the request to give the guardian authority to change the code status for your wife?
Yes, sir.
Okay. All right. Thank you. Mr. Brown, do you agree that code status authority or the authority to change code status should be granted to the guardian?
Based upon the testimony, I would agree, Your Honor.
And I forgot to ask you, did you have any other examination of Ms. Dalzell, Mr. Brown?
I do not. Thank you.
Okay. All right. So I appreciate Ms. Dalzell raising her hand. I credit her testimony and further note that all family members concur with the suggestion that she made regarding code status authority. And given the circumstances of the potential life expectancy, as well as potential hospice isn't always an issue, but I know that generally speaking, not having the ability to make code decisions sometimes interferes with going into hospice, which oftentimes is contrary to the best interest of somebody who's at that stage of their life, given their current healthcare circumstances. And so that's a consideration. All family agree with granting that authority to the guardian. I don't have any indication of prior healthcare power of attorney documents or any code designations like a DNR or code designation would be medical facility. So the authority would need to rest with the guardian, and she appears to have a reasonable likelihood of having some other events that might require some type of resuscitative activity. And so based on that and the position of the guardian ad litem, position of the family, the court's crediting Ms. Dalzell testimony, I will order differently than I typically do, but I'll give Mr. Glenn Watkins II the authority to go ahead and make changes to code designation. The way this works, Mr. Watkins, is I do not tell you to make her a full code or no code. I give you the authority to make that decision based on her best interest, based on the information you have at the time, because you're the one that's on the ground and has the latest information. So I just wanted to make clear to you that when I give you that authority, I'm not saying do it or don't do it. I'm just saying with the information you have with the healthcare professionals and what you think is in Ms. Watkins' best interest, you have authority to keep her at full code or to make her no code, depending on what you think is in her best interest. Do you understand that?
Yes, Your Honor.
Okay. All right. And then Mr. Glenn Watkins II, do you have any questions? Since I'm going to appoint you as guardian, do you have any questions based on anything we've gone over today?
No, sir, not at this time.
Okay. All right, then I will issue an order that conveys that authority to you, and I'm essentially filling in for not Otsego County Judge this morning. So when I get that order and paperwork from the Otsego County staff, I'll get it executed and get it back to them. So not that takes a huge amount of time, but there's just a couple more channels of communication than we would normally have if I was up there in Gaylord. So we'll get that to you as soon as we can, and somebody will, I'm sure, be in contact with you if you want to pick them up at the courthouse or have them sent to you in some other way. Okay?
Yes, thank you, Your Honor.
Okay. All right, then we will stand in recess. I appreciate everybody being available, and we'll get that order entered and letters of authority and get them distributed. All right, court stands in recess.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you.